I get around, yeah, get around.
Welcome to the Westmount Estates on the move with property pros Shaun O'Connor, property law and conveyancing specialist. With 4 decades of experience in the Jersey property industry, I'm sure that both first-time buyers and seasoned buyers and sellers alike can all learn something from you today. Good morning, Shaun. Welcome.
Good morning, Jeremy. Nice to see you.
Nice to see you too. Glorious sunny day.
Yeah.
A little bit overcast.
Still warm.
Yeah, but with no air conditioning in the car, it's quite a nice respite. I'm going to start off just by asking you a few questions, and then at the end, anything if you'd like to add.
Okay.
Yeah, so for our listeners or people watching, to get a bit more of an understanding of the process involved in your role, can you walk us through the entire property transaction process from start to finish, from both a buyer's and a seller's perspective?
Yep, sure. In Jersey, it's a lot quicker than people realise. The process from making an offer on a property or accepting an offer to actually completing is something in the region of about 4 to 6 weeks in Jersey, which, believe it or not, is half the time that it takes in the UK or the rest of Europe. Most transactions are subject to contract, so neither party are bound, and so if circumstances change or there's something fundamentally wrong, either side can actually walk away from the transaction, which is one of the reasons why the Jersey system tries to get to completion as quickly as possible. And it really depends on whether or not there's a chain of transactions or the financing arrangements for people in the chain. But if it's a nice straightforward transaction and you manage people's expectations, then it's normally 4 to 6 weeks from the day you make an offer to the day you get your keys, hopefully. So once someone like Jeremy has negotiated a deal, he sends out a sale instruction to the lawyers appointed on both sides for the vendor and the purchaser. And then they contact each other, and the vendor's lawyer has to draft up a contract of sale, or conveyance as we call it, which sets out all of the boundaries, all of the clauses and restrictions and rights that go with that particular property, the terms of the deal, that being the price, matters to do with vacant possession, and that is then sent across to the buyer's lawyer, and then it's the buyer's responsibility to guarantee title. Unlike the UK, we don't have a land registry where the government guarantees title. So the purchaser's lawyers, and in fact the vendor's lawyers, have to take out very expensive PI insurance, that's professional indemnity insurance, because if they get something wrong or something slips through the net, it's the lawyers who are on the hook, not the land registry. So we do have a public registry of deeds where all the deeds are kept, going right the way back to the 1800s and even further. We turned from French into English in around 2007, 2008. So all new contracts are now drawn up in English. But if you go back further than 2007-ish, then the contracts, to research them all, if you're checking a particular title on a property, then you have to then work in French from that period backwards. At the moment, prescription in Jersey is 40 years. So it's the duty of a buyer's lawyer to check back the title a minimum of 40 years to guarantee title. So that research part is normally the first part of the conveyancing process for the buyer. And we then also send out search inquiries to all of the local utilities like Jersey Water, Jersey Gas, Jersey Electricity, and also the planning department and the parish authorities and the infrastructure department, basically to find out all about all the services, the drains, whether or not the building's listed, whether or not there's any planning conditions, whether or not there's been applications that have been turned down, basically so we can gather as much information as possible for the buyer. And the way I always worked and the way I was trained is you have to deal with every transaction independently. They're not all the same, no clients are the same, no circumstances are the same. So you have to almost put yourself in the client's shoes, and you say to yourself as you're doing the research, going out and checking the boundaries, getting these search replies back from the local authorities and utilities, you have to say to yourself, what would I want to know if I was buying this? And then certain properties like flying freeholds, share transfers, where all of the terms are wrapped up in either a declaration of co-ownership or a memorandum of articles if it's a company. Those are the rules and regulations as to how you can live day to day and how it's all administered. So again, you don't want to just find this all out after you've bought. You need to know as much information as you can before. And if you do find any problems, then before you've committed, then we raise them with the seller's lawyer. And there might be a boundary tidy up that's needed. There might be some issues with a mistake in one of the previous conveyances, or the articles of the company, or the declaration of co-ownership. So when we find those sort of things, we want those little things sorted out before, because then the seller has to pay to fix them. And once everybody is happy, the bank documents, if you're getting a mortgage, are all in hand, then we have a completion meeting, normally the week that it's going to court, and arrange to meet you to take you to court, or sign a power of attorney if you don't want to go to court, if you want to get on with the moving on a Friday afternoon. And then we arrange for the handover of possession and keys. And the actual monies change hands. You go to court and take ownership on the Friday, but with freehold, flying freehold and leasehold, the monies don't change hands until 2 working days after completion. But with share transfer, you complete and settle up the consideration on the same day, because you're buying and selling a chunk of shares. So that's pretty much a walkthrough of how the system works in Jersey.
Thank you, Shaun. And what are the common challenges or delays encountered during property transactions, and how can they be potentially mitigated?
Well, from experience, I would say it's managing people's expectations as to whether or not something's realistic, and then communication, because lawyer to lawyer, we need to liaise with each other. We need to know whether or not there's an onward transaction, and if there's any delays in the chain, that information's got to be passed down to other people affected. And also, you'd be amazed how many people contact me and say, I'm buying and selling, and I'm going off skiing for 2 weeks. And I'd say, have you sorted out your finance? Oh no, I'll do that when I get back. And of course, suddenly you go from a 4 to 6 window to 2 weeks being lost. And you can't really do the process now unless you're compliant. JFSC are very strict now. So we can't start doing actually any legal work on the conveyancing until we've got all of your CDD, which is client due diligence, and it all has to be done properly before we can actually start working on the matter. And people who are busy with their own jobs, or travelling with work, or going off on holidays, means that managing those expectations can be difficult sometimes. So communication is the most important thing between the estate agent, between the lawyers, and in particularly with the clients.
Absolutely. And can you explain what a title search is and how it impacts on the buying process?
Yeah, as I mentioned briefly before, it's the buyer's lawyer's duty to guarantee title. So you have to check back on all the previous owners in the land registry, which is called our public registry of deeds, for a minimum of 40 years. Now, the property may have been inherited, so you might have to go back further than that, to the last time there was a contract passed in court setting out all of the boundaries and the covenants and easements and things that run with the property. So that is probably the majority of the work, the research part of it. And I think a lot of people think that, it only changed hands 10 years ago, so you just change the names on the top and tail of the contract. But it's not quite as simple as that, because as we know, people change things, boundaries get changed, people put extensions on, could be disputes. A big dispute that pops up these days, which comes out in what we now have as a seller's questionnaire, as to whether or not anybody's fallen out with their neighbours, are things working properly. People argue over parking all the time, because most of the housing estates and closes were designed for 1 car per household, and it's quite normal now to have 2 or 3 per household. So we get a lot of queries about parking rights. But the title research is the bit that takes up the majority of the time, followed by actually physically going out to the property, armed with a copy of the contract of sale that you've checked the title on, to then verify physically that what's on site matches up with what's on paper in the actual contract of sale.
Super, thank you. And are there any specific local issues or regulations in Jersey that buyers should be aware of when purchasing a property?
Well, things change all the time, but planning is obviously a big one because that's a moving beast, really. Fire regulations is now, especially for so many apartments in the island, you need to make sure that it's properly fire regulated. As far as the actual conveyancing side is concerned, boundaries are things that come up all the time because people tend to change things or move things. You know, they replace a fence with a wall and didn't put it in the right place, things like that. But the big one is there's sometimes people would have sold off a property and retained next door, so they wanted to restrict what could or couldn't be built on the property they were selling, perhaps to protect a view or something like that, or they didn't want extra building next to them, so they put a restrictive covenant on the land. And it's amazing how many properties I've dealt with over the years where people have built on those restricted areas, and of course the next time they think, oh well, I got planning permission, so it must be okay. But then the next time the property comes to change ownership and the lawyer checks the deeds, they see that they've encroached into a restricted area. And then you have to find out who's got the benefit of that restriction and then negotiate with them to lift the restriction and ratify what's been built in the wrong place. Or if it involves lots and lots of people who have the benefit of it, then we look to get an insurance policy called a defective title indemnity insurance, so that you put it to the insurers and say, this extension's been there for 30 years, no one's complained, rather than go and tap up half a dozen neighbours, one of them may say no. You ask the insurers to take a one-off policy to cover the risk, and once it's been there for 40 years, then nobody can do anything about it, because that's the prescription period I mentioned before in Jersey.
Thank you. That partly answers my next question, which was how do you handle issues that arise from property searches, such as boundary disputes, like you mentioned, or easements?
Well, it's negotiation with the seller's lawyer, and of course, if I'm acting for a seller, I'll try and make things as smooth as possible for them. And if somebody's being over pedantic on the purchasing side, then quite often you have to say to them, well, sorry, but you'll just have to accept that it's not a major issue. And then when you're acting for a buyer, obviously you need to make sure that if something's not perfect and they won't fix it, that the buyer is fully aware of that, because you know what you don't want them saying, oh, I didn't know about that, or it become a bigger problem when they come to sell. And I tend to have a traffic light system. Is a problem really serious? Then it's a red. If it's somewhere in the middle, it's a case of taking a view maybe, then it's an amber. And if it's a nice clean transaction and everything's all as it should be, then it's a green traffic light. And then it's all back down to negotiation and communication between all the parties.
Thank you. Are some contracts still written in French?
No, not anymore.
No, okay. Yeah, so that I mean, obviously it's a key part of your role to be able to translate.
Well,
can AI do that for you
No,
now?
unfortunately, it's a sort of Jersey legal French. If you spoke like that kind of French to a Frenchman in mainland France, he'd think you'd swallowed a dictionary.
Okay, thank you. Can you explain the importance of understanding the terms and conditions of a property contract before signing?
It's vital, because you need to know your rights, and you need to know any restrictions and in fact boundaries, because a lot of people, when they buy something, they intend to improve it or make some changes, and they need to know, for instance, if your drains cross someone else's land or service pipes and they ever need repairing, then you need to know that you've got rights to go onto neighbouring property to carry out any repairs, whether or not it's to your drains, your gable end of your house or whatever. So you need to know your rights, and you also need to know your restrictions. And that's really what the completion meeting is before you buy. And for a particular property where it might be a bit more complicated, then I often arrange to meet the client at the house and walk the boundaries and explain the contract to them physically on site, because it's easier to understand if you're physically there. But most of the time we can do it using plans, an aerial shot of the property in the office, and it's only if somebody has got a specific concern that we might say to them, well, look, let's actually meet you out on site.
Okay, super. And you mentioned earlier share transfer, freehold, and leasehold.
Yeah.
What's the difference between freehold, share transfer and leasehold properties, and what should buyers know about each?
Yeah, well, freehold's very straightforward. You own everything from the bottom of the earth up to the top of the sky. So within the perimeters of your property, if you're buying freehold, everything below the property and everything above the property is yours. The other three, leasehold, share transfer and flying freehold, they're all different ways of owning an apartment or flat. And the history behind why we have these different choices was fundamentally going back to the 60s to do with how people were buying apartments, but how they would be able to get financing over an apartment where they don't own from the floor to the sky. They own a piece of a building or rights to a piece of a building. And originally, like for instance at Le Kennevet and Clos de Sable, the states of Jersey built those flats, so they were the landlords, so they owned the buildings. And the buyers of those originally were all first-time buyers, so they were able to get funding from the states of Jersey for states loans. But no other bank would ever lend on them. No private lender, one of the main banks, HSBC, Santander, Barclays, all the main ones, they wouldn't lend on leaseholds. So then we evolved into share transfer, where you're buying a block of shares in a company. The actual company owns the property, and you're buying the exclusive rights linked to your block of shares to occupy a particular apartment, and then you have communal rights to certain aspects of the property with the other owners of the other apartments who own separate blocks in that company. And the companies are administered by a memorandum of articles, which are the rules of the company, and the owners often get together for annual general meetings, or there's a specific problem, and they arrange maintenance, they arrange service charges if there's regular outgoings, but it's all administered the way a normal company is run. And you have to have a company secretary, you have to have a set of books, and each time an apartment changes hands, the shares have to be transferred on the company records from the old owner to the new owner. Then we brought in flying freehold, I think it was in the early 90s, and basically it was a copy of the French law, so that you could get funding on buying an apartment where you didn't own from the floor to the sky. You owned a chunk of the building, whether it was ground floor, first floor, top floor, whatever, and then that is administered by a very involved document called a declaration of co-ownership. And it's a bit like the memonarts for a company, but it's registered in the land registry, and then divides the property up into the various units, which are called lots, and then the buyer acquires by separate contract before court the particular apartment or lot that they're looking to purchase. You can get mainstream bank lending on flying freehold. You can get mainstream lending on share transfer. In theory, you can get lending on leasehold, which more often than not were 99-year leases, long leases. But in practice, very, very few lenders are willing to lend on leaseholds. And by comparison to the amount of share transfer and flying freehold apartments, there are actually quite a modest number of leaseholds. And in fact, the ones I mentioned before at Clos de Sable and Le Kennevet, when it came to those changing hands in the last couple of decades, it was decided to take them out of leasehold, so the states of Jersey gave up the ownership of the building, and they were all converted into flying freehold, so that each time they change hands now, people can actually get mainstream lending on the purchase of that apartment, because it's now no longer leasehold and has been turned into flying freehold.
Could you explain how Westmount works? Because obviously those are share transfer transactions.
Yeah.
Where does the leasehold element?
Right, well what happened is the parish of St Helier owned that. That was a former quarry that's been there for hundreds of years and been redundant for over 100 years, with huge rock face all around it. And so Dandara were the developer, and they negotiated with the parish of St Helier that they would take 999-year leases in 4 separate chunks for the 4 buildings that they were going to put on Westmount, and 4 companies were formed and took on those 999-year leases. And then the companies were then chopped up into various chunks of shares for each of the buildings, so that the eventual buyers did the normal thing with share transfer, was buy a chunk of shares in a company that didn't actually own the freehold, but it had a 999-year lease, which is effectively forever. It will certainly outdo our lifetimes, but it was linked to the fact that the physical condition of that particular site was an ancient quarry, which the parish of St Helier technically are still the legal owner and therefore liable for, and so that the developer was then only they put a huge amount of hundreds of thousands of pounds of infrastructure in, because of the drainage and because of the quarry and making the rock safe, etc. But it was decided that in this particular instance, with it being parish, that was done in a slightly different way. But a 999-year lease is, to all intents and purposes, means that the companies that own those blocks will own them for effectively forever.
Okay, great. What are the typical costs involved in a property transaction, including legal fees and how?
Yeah, well, it's on a case by case. We used to have fixed fees on a percentage basis. That's not the case now. So I would say, as a rule of thumb, you're looking at somewhere between 0.4 and 0.5% of the value of the property. But it really depends, because I might get an instruction from somebody on a flat or a house that I've already dealt with before. So we try and get as much property information from the client when they first instruct us. Before we give you a quote for your fees, we'll take a quick look at it and try and assess how much work's involved. And sometimes, there ends up being a lot more work that you didn't anticipate, and sometimes you end up finding that it's actually a lot smoother because you may have had some prior knowledge on that particular estate or house or flat. So it really is on a case by case, and it also depends whether or not you're also selling as well as buying. And it pays to shop around, because you would do that with any other profession, or builder or tradesman. So I would always advise people to get 2 or 3 quotes, see how the communication is, see what your general feeling is, and then make an assessment in the same way as you probably choose your estate agent or your builder or anyone else. As far as disbursements are concerned, your biggest outlay is going to be property tax, which is called stamp duty in Jersey, and that's on all types of purchases, including share transfer now. It's on a sliding scale, and if you're a first-time buyer, you effectively get a leg up with minimal stamp duty or property tax up to 600, and then if you're buying over 600,000, then you pretty much end up paying the norm as anybody else that's a non-first-time buyer.
I think the threshold's increased to 7 now, but
but between 6 and 7,
it's very marginal, isn't it?
They've upped it, so you end up almost paying the same as anyone that's non-first-time buyer. So I think for most people, their biggest outlay is their stamp duty tax. So the government wins again. It brings in a huge revenue for the government, millions and millions a year. Then your more minor disbursements are the cost of those search letters I mentioned before to the local utility companies and parish and planning and infrastructure authorities. They all charge to check their records and provide us with information about the property that we then relay on to you. So you're effectively paying for those searches because they're charged for by the various companies that we have to inquire with.
That's it.
That's pretty much, generally speaking. If you don't decide to go to court yourself to complete, if you're buying freehold or flying freehold or leasehold, then we have to appoint an attorney to put their hand up in court for you to swear an oath on your behalf. So there's a stamp duty of, I think it's about £90. We normally don't charge for the power of attorney, it's included in the conveyancing fee. But if you can't physically get to court at 2:30 on a Friday afternoon, then we have to register this power of attorney with the court to show that we've got authority to go on your behalf.
And you can do the same with share transfer as well.
With share transfer, we can sign on your behalf, but the difference is that's done in the office by way of a private exchange of contracts, and it doesn't need to go to the Royal Court.
Super. Thank you. Stamp duty is the main tax everyone's aware of, and estate agents don't give any advice in relation to tax generally, but do lawyers? I mean, you probably don't get involved in.
Well, we certainly, I mean, you know, the stamp duty calculators are readily available. Most law firms have got one on their websites. The actual land registry itself has got one. So it's very easy to, you know, if you put an offer in on something, it's very easy to put the amount in online, get an idea of what you're going to get whacked with from the tax man. So it's not really tax advice, because it is what it is. You are charged what you are charged. Where GST has crept in, non-residential property transactions do incur GST. That can be buying a car parking space, buying a piece of open land, buying a commercial premise, buying a warehouse. And there's normally a GST provision in the contract of sale, because technically it's a seller's tax. But quite often the deal is negotiated where the GST is passed on from the seller to the buyer. And that's one area that is always changing, and it's one area that lawyers do not pretend to be experts in. So we always advise that you take GST advice from a qualified accountant.
That's great. How do you ensure clear and consistent communication with clients throughout the property transaction process? You know, we hear people, buyers and sellers, you know, quite often, depending on who's involved in the transaction, everyone's working towards a completion date, and then a week or two before the transaction is due to take place, all of a sudden there's a load of questions, a load of searches that haven't been done, which perhaps should have been done already. You know, how do you approach that, and how do you keep that clear communication going throughout the process, and no nasty surprises at the end?
Yeah, well, I think it's no different to any other profession. There's good and bad in every profession. Some people are too busy. Like a busy builder, they take on too much work, make promises that they can't keep, which is why you have to manage expectations. There's a lot of activity at the beginning of a transaction where you've got to get the compliance sorted as quickly as possible so we can get cracking, gather as much information about the actual property itself, and then it can go quiet for a couple of weeks whilst the buyers sort out their finance. They might be waiting for their offer letter, they may be still filling in paperwork with their bank. And more often than not, most transactions are held up by the paperwork for people's finance. And that can often dictate, you might have set a particular target date, but if the mortgage paperwork and the mortgage lawyers aren't ready, then it often does spill to a delay by a week or two. And then there's a flurry of activity, generally speaking, when the mortgage documents are in, when we have to take monies off the client the week that it's completing. We have a completion meeting, or perhaps a site meeting, to go through all the finer details so that nobody is in the dark about what they're buying. And then most of the time, I mean, I prefer to use the telephone. I'm old school, but you know, everybody's on email, and of course most of our clients are busy working in their day jobs. So there's email. It's quite normal for email traffic to start at 7 in the morning and still be going at midnight. And a lot of people have got email not just at their desk, but on their laptops at home or on their phones. So email has taken over our lives, we all know that. But if there's an issue, and it's important and it might delay things, to me, the thing to do is just pick up the telephone and to talk to somebody, even if you have to interrupt them at work, and say, look, you might not read this email until you get home tonight, but this is going to jeopardise whether or not you should be filling boxes or not to move next week. So I'm calling you to tell you that, you know, there's a slight change of circumstances. Not everybody does that. Too many people hide behind emails, and of course people are in and out of meetings. They might work on site or something and not get to their emails till maybe half a day or even a whole day after it's been sent. And in that vital last week, when you're trying to piece everything together, communication, quick communication with everybody, between the agents, between the clients, between the lawyers on both sides, between the bank that's lending, perhaps people that are further up and down the chain. You know, it is a case of tying all those loose ends together. But as I said at the beginning of this, that's one of the reasons why the Jersey system goes from offer to completion as quickly as possible, to try and flush out these issues. And I'll go back to my other point, which is sometimes people holidays, or they take on work and they've already got too much on, and they're not open and transparent that it's not a realistic time frame. And it's much better to be honest and say, look, there's no way that's going to happen within 4 weeks, so people can plan their lives around that.
Thank you. And I think there's an expectation sometimes, particularly for people who haven't transacted before, that, you know, come 2:30, you know, they're getting the keys on the court steps and moving straight in. But that's not always the case logistically, is it, Shaun?
No, well, I would say in most transactions, people have to have an element of sort of flexibility where you at least allow, you know, maybe the Saturday morning, you can have the keys, but, you know, people that have been busy trying to empty out their property, you know, most people want to leave it in a nice condition, so they want to go back and mop up behind them and clear. There's always an extra dump run. So most of the time, people negotiate sort of a bit of flexibility over the course of the weekend. You can't really delay it much more than that without permission from the bank, because the banks don't want to lend money where there is potentially the old owner still in the property, because they're taking on the liability of a sitting tenant. If you don't pay your mortgage and they have to foreclose, and you've got somebody that said they were going to move out but didn't move out, then it causes a problem to both the new owner and whoever's lent them their mortgage. So, you know, we're all human. There's got to be a bit of give and take, and that's some of the discussions where people like Jeremy, who can talk to both parties, come in very handy in the run-up to the completion date to say, well, look, you know, we'll give you the keys on the Friday, but, you know, do you mind if we have some of the Saturday? Saturday lunchtime is normally the handover time, so that the old owners are clear, and then the new owners can come in their removals sort of during the Saturday.
Yeah. And it's always the top of the chain which dictates.
Yes,
that
it does,
process.
unfortunately, yeah. And then again, you often get properties that are already empty. It may have been inherited and it's already clear. And people that are completing on a particular week who want to get ahead of themselves because they're busy with their daily lives, they'll ask if informally, if they're definitely going to complete that week, can they start moving in a few boxes or a few bits and pieces a day or two before if the property's empty, even if it's just to store it in the garage, because then that saves time in getting in over the minute they've completed.
Okay. And how would that work with insurance? If property transacts on a Friday,
Yeah.
through the Royal Court, and then the new owners are taking possession on the Saturday,
Well,
what would happen if something devastating happens to the property, like a cylinder popping or flood or?
Well, with any type of purchase, you have to be insured on the day you acquire it, regardless of whether or not there's a flexibility on the handing over of possession. The day you become the legal owner, you are legally liable for everything and anything to do with that property. So your lending bank will insist that they see a copy of your building's insurance. If you're buying into a block of apartments that's either in a company for share transfer or a flying freehold association, it will already have a block policy in place, and then that we would need a copy of that to then for you to see, to know that you're fully insured, and also to provide to your lender so that they can see the terms of the insurance cover, because no lender will secure their money on a property unless it's fully insured on behalf of the new owner from the day they become the legal owner. There's a slightly separate insurance, which is your contents insurance, which is not as vital as the actual structure of the property against any kind of floods or fire damage. But your contents insurance, you'd be surprised how much value we all have, whether or not it's jewellery, paintings, tech equipment now. It's absolutely vital for relatively modest premiums, I hasten to say, to ensure that on the day you buy the property that you've also taken out contents insurance to make sure that anything inside of the property that's movable is also fully insured.
Thank you. And what made you choose a career in property law?
I had no idea what I was getting into. I went for a job as an insurance clerk, would you believe? And then I went for a job as a trainee conveyancing clerk. And all I understood was the word clerk. I didn't really know the difference. And it was in 1982. I was 16 years of age. And the insurance company offered me £15 a week, and the law firm offered me £25 a week. So if you want to know the truth, it was the tenner that made the difference.
Fantastic. And what advice would you give to someone considering a career in property laws? I know there's quite a few conveyancers coming up to retirement in the next couple of years,
Yeah,
and might leave a bit of a gap in the.
There is a bit of a brain drain coming. It's one of those professions where it starts off as an apprenticeship, where you learn on the job, and you have to get your hands dirty. You have to do the menial tasks, and then you build it up. And I would estimate you need 5 years minimum training. You need to understand French, even if you can't speak it fluently. You need to be able to read written French, because you have to unpick old ancient contracts that go way back sometimes as far as the 1800s. And certainly before 2007, every conveyance that passed before court was in French. So it's vital. If you don't want to learn French, don't go into conveyancing or property law. And then after your 5-year apprenticeship, you start be given a bit more responsibility, where you'll deal with transactions on your own without being supervised, and you gradually build it up. I would say probably you need to be doing the job hands-on, supervised and then unsupervised, for a minimum of 10 years to become the full product. And then a lot of people then decide to study, take either specific exams to do with property law, or go on to take the advocates or solicitors exams, so that they have rights of audience to stand up in court and present cases, or just because they've decided to stick at property law and go that little bit further and actually qualify as an officer of the court. But as Jeremy said before, unfortunately, there's probably more money now in finance. You can get up the ranks a lot quicker than a trainee conveyancer or property lawyer, and people are much more ambitious to get going and earn the higher bucks in their early 20s as quick as they can. And it is a very specialised subject, and I have seen literally dozens, if not hundreds of people over my time start the process, to get 2 or 3 years in, realise it's a bit of a strange subject, full of quite a few weird characters like myself, and they then decide it's not for them.
Yeah. Thank you. And can you share any memorable experiences, hold fire, any memorable experiences where your intervention made a significant difference in a property transaction? You can tell me some memorable experiences after.
Well, yes, well, there's been many. Obviously, client confidentiality means I can't disclose the property or the people involved. But using my traffic light system, there has been many occasions over the years where we found a problem that may have existed for quite some time. It makes the property very difficult to sell on, and you just have to sit down with the client and say, don't buy it. That's the big red light. It doesn't happen often, but it's happened because I've been doing it for so long. I've had many cases where I've had to say, putting myself in the client's shoes, I wouldn't buy this, walk away. Mm-hmm. And then obviously it's not all about the legal side, because the legal side may be all fine, and then suddenly they get a disaster in their survey to find out that they've got to find another 50 grand budget because it needs a new roof, or there's rising damp, or it doesn't have proper foundations. So quite often a lot of deals, because you wouldn't buy a car or a caravan or a boat without having it checked out. With property it's a bit crazy really, because you get someone else to check it out for you, but you don't get a chance to test drive it. So you often might find things after you've bought that you didn't know were there. So we always recommend people get a survey and have it properly checked out. And even if it's been, relatively new, purpose built, we'd always say, look, go back as many times as you need. Turn on the taps, open the windows, make sure things work. And the sellers have a duty now to fill in a questionnaire. There's about 25 questions on it, where if they know if something's wrong, they have to disclose it. And if you discover after you've bought the property that they've not told the truth or tried to cover something up, then you have 2 years after you've acquired to go back after them and sue them for damages for misrepresentation. That's only been around about 5 years now. We didn't used to have that. The law of the land used to be buyer beware. And so the worst case scenario is you have to advise a client if it's something that's just going to cause them a major problem and make it difficult to sell on the property, you just have to say to them, walk away.
And if the seller has completed the questionnaire
Yeah.
in good faith and isn't aware there might be a drain issue that's lurking or something, what would be the implications there?
Well, if they genuinely have answered the questions with the knowledge that they've got of the property, then that's another reason why we say to the buyers, yes, they've answered the questions, but when it comes to practical things, especially if you've got a private drainage system on the property or private borehole water system, or if it's quite an old property, like say a granite cottage in the countryside, then get a plumbing business to go around there and check the drainage system or check the private water system, and get a builder or a professional surveyor to thoroughly check out the property from top to bottom. So even though the seller may have been honourable, there's certain times where they genuinely wouldn't know. And with inherited property, you often have children that have inherited a property from their parents. They might not even live in Jersey anymore, and so they've not lived in that property. If the parents have passed away, they don't have the practical knowledge because they've not physically enjoyed the property. So that limits the detail in which they can answer the questions. Which it goes back to the buyer beware provision has never really gone away. It's better to be safe than sorry. And one thing I would point out is a lot of people that are getting mortgage lending, they think they're getting a survey as part of the mortgage valuation process. That is not a survey. That is a ticking of boxes saying what the property consists of, what its value is, so that the lender is happy that what they're lending on is of sufficient value to cover their mortgage criteria. And a lot of people, especially first-time buyers, will say, I'm already getting a survey with the bank. That's not a survey. A survey is someone that goes out independently and will look at the property the same way that a mechanic would look at the car from top to bottom, and if they see anything nasty, then they will either tell you immediately to go and see a specialist if you need an engineer or a damp specialist or something like that, and they often will then produce a full survey report so that you've got a permanent record as to their inspection. Some can be quite expensive. Some of the local surveyors will actually do what they call a walkthrough for you, where they will go to the property for a few hours, they'll do an inspection, give you a verbal set of advice, and if they spot anything, some nasty cracks or damp or anything like that, then they'll put you straight onto a specialist and you can cut to the chase. So we would, as I said before, we would always recommend that a buyer has a survey. If you're buying in a brand new block of apartments and you're getting a mortgage valuation, well, that's slightly different.
Some mortgage providers will insist on a more in-depth survey, won't they?
Some of them do, yeah.
Particularly in elder properties, or in what other instances?
Well, certainly independent properties of age, you'd be absolutely daft not to get a proper survey independently for yourself. If you're buying into a block of apartments, if for instance it's a converting townhouse that may have been up for hundreds of years, that's been converted into flats, well, you're still liable for a share of the structure of that building once you buy your apartment. So, those sort of properties, they may have changed hands many times, and you're only focusing on putting the key in your particular apartment. But if the roof goes, or the structure goes, or the foundation goes, as an owner of an apartment in that block, whether or not it's share transfer or flying freehold, you're liable for anything structural to do with that property together with the other owners. So better to be forewarned. With purpose-built apartments, the newer ones over the last 20 years, then you're a little bit safer, and you could probably make an assessment on a case-by-case. We'd always advise, depending on the address, whether or not a mortgage valuation survey is sufficient in that instance. But it is amazing how a lot of people think that they're getting a survey done through their lender and don't realise that they are actually sometimes best advised to get an independent survey, depending on the property.
That's really helpful, thank you. Is there anything today that I haven't asked you that perhaps we ought to cover, which are pertinent to buyers and sellers?
Yeah, I would say always ask questions. I mean, I joked before about lawyers and conveyancers being a bit strange, but we are actually quite normal people, really. And I know, there's so much goes on in a move, from viewings to making a decision to getting your finance, then the practical side of transferring services, packing, removals. You know, there's so much going on. Plus, people are trying to keep down their daily lives and doing their jobs. You know, I've sat in many meetings with clients, and they're just overcome by the whole process. So each client's different. Some people want everything explained to them, every trail of paperwork. Others, especially if you build a rapport with them and you've got their trust, will just say, if it's fine, Shaun, it's fine, where do I sign? And you then keep it to a minimum and only tell them if there's anything nasty or things that they need to be aware of. But I would always say to clients, don't be afraid to ask questions. Don't be afraid to take 5 minutes out of your day and leave a message or send an email, whether or not it's to your agent, whether or not it's to your lawyer, whether or not it's to your lender, because it saves time. And people sending emails or waiting for a letter to come in the post, if we're trying to get it through and manage people's expectations, or there's a change in circumstances, you know, suddenly your granny's come ill and you can't move that week, the quicker the communication and the quicker people ask questions, the quicker we can find the answers.
And adding to that, I think it's right to say that most legal fee quotes for conveyancing are fixed fees. Obviously, a lot of people know lawyers have quite a high charge out rate for the hour, you know, having worked at various law firms in the past myself before embarking on this career 25 years ago as a real estate agent. We were told to bill, if you went to the toilet, think of a client and bill them. Should buyers and sellers who've got these fixed fees be concerned about, you know, emailing or picking up the phone to their respective legal representative?
Not at all. The type of law you were referring to is litigation, trust law, criminal law, commercial law, where it's basically on a time spent basis. And yes, you're right, certain aspects of law firms charge by the minute. With conveyancing and property law, clients can take comfort from the fact that when they're given their estimate for costs on a case-by-case basis, then that will be what they're charged on top of. And stamp duty tax is not a legal fee, by the way. That's a government tax. Same with the disbursements for the search inquiries. If we get into the transaction and we find a particular problem that is going to involve more work than actually dealing with the conveyance of the home move, then we always have to reserve the right to address that issue. And if the client still wants to go ahead and have the problems fixed, especially if they're more than just a boundary tidy up, you know, something really involved that will involve an application to the courts or getting an insurance policy that's really detailed, that requires lots more research and therefore lots more time, only if the client says that they want to go ahead, and that's why communication is important. Then if you want us to do this extra work so that you can buy a property that's clean and we solve the problems, then we'll have to make another assessment as to what additional work we think would be involved, and then that will be added to your original fixed fee. But that's always by letting the client know. We're duty bound under the Law Society rules. We can't just quote you, say, £3,000 for a conveyance, and then turned out that, you know, there was more time spent on it because you phoned or popped in every day or sent emails every day, that we ended up putting more time on it. We're not allowed to then miraculously go, oh, it's now £5,000, unless we've come back to you as the client, explain that there's more work involved for whatever reason, and that we will have to reassess the original quote.
That's fairly rare, I would say.
It's fairly rare. So people can, in conveyancing and property law, people can take some comfort that they're not using a litigator, hopefully, they're not using a commercial lawyer or trust lawyer, and so the clock is not ticking. But there are some occasions where, you know, in the same way as you might ask a builder to come on site and build you an extension, he demolishes your old one, he suddenly realises the foundations are faulty, and what he thought was going to be £20,000 worth of work, new foundations are now going to be £40,000 worth of work. You know, sometimes you can't find out if there's going to be unexpected extra work until you start the process and get down to the nitty-gritty. And that's why it's important to instruct your lawyer as early as you can and make sure that they're getting on with it as quickly as possible. and they're not checking title and checking boundaries the last week. They should be doing that the first or second week.
Thank you.
The other thing I will just say is we often get instructions from clients that say, we want to use you, we'll do the compliance, but we don't actually want you to do any of the work yet because we want to wait for our mortgage to be approved, or we want to wait for the survey to come through to make sure that there's no nasty surprises. Well, that's fine, but you can't then expect the lawyer that was given, say, 4 to 6 weeks to do the legal process to then wait 2 or 3 weeks and then be expected to do it in half the time. So that's why we go back to the communication. But it's perfectly fine for a client to say, yes, you're instructed, yes, we accept your fee quote, but please don't do any work yet. And we then have to say to them, well, fine, for every week you ask us not to do the work, expect an extra week to be added on to the end completion date.
Yeah, that could be occasionally difficult for an agent to manage, estate agent to manage,
Sure.
When you're acting for a vendor, and speed of transaction was one of the key drivers for them accepting an offer. As agents, we don't generally hear that as a condition of purchase at the time of the offer, so
No.
that can create a few headaches down the line. So advice to buyers would be, if they are to make an offer, make it clear that lawyers won't formally start work for them until certain obligations or checks or searches have been ticked. And
Well, being the agent, you can talk to both parties. Once we're instructed, our duty is to our client and only our client. So we can't speak to the other party involved. We can speak to their lawyer, but we can't speak directly to the opposite party that we might be instructed by. And if our client tells us to hang fire or take our time or look at a specific problem before they want to give us the green light to go ahead totally, then we have to do what our client instructs us. And that includes confidentiality, that includes halfway through the transaction if there's a change of circumstances. They might have had a refusal from one lender and then they're going to have to shop around for another. We have to keep our clients' instructions confidential and act accordingly on their instructions.
Yeah, got you. And with the nature of selling and buying in Jersey, I think a lot of people, particularly people who've perhaps dealt in transactions before coming to the island or settling in the island and having to go through the local process.
Yeah.
Obviously, there's no exchange in Jersey.
No.
There's no real protection for the buyer or seller until you've got the keys in your hand.
Well,
and anything could effectively happen.
Well, on most transactions, we go straight from offer to completion in the way I've described before, but there is a mechanism in Jersey, and it's called a preliminary agreement of sale. And quite often for larger properties, the high-end ones, or if there's going to be a long time delay, somebody says, I'm selling, I've accepted an offer, but I'm not moving or completing for 6 months, then for peace of mind, to make sure they don't take an offer from someone else, or the buyer doesn't walk away because it's a change of circumstances or they find something else, we do all of what we do in the normal 4 to 6 period, but instead of going to court, both parties sign a preliminary agreement of sale, which is a binding contract between both parties, and then it's a case of counting down the months on the calendar to the agreed end completion date. So they are often used for higher end and longer drawn out transactions, and within that contract there's a thing called a penalty, which is a financial penalty, and it's normally 25% of the value of the property. So let's say you're buying £1 million house and you sign up both parties unconditionally, no strings attached, to get to the final signatures by both parties. If either party pulls out, then they will be in for a penalty, a financial penalty to the tune of £250,000. And the idea of that is to stop people from trying to wriggle off the hook. And normally, although it's negotiable, these preliminary agreements of sale would also mean that at the point of signature, with a delayed completion, several months normally, they would put down, the buyer would put down a deposit that's held in escrow by the seller's lawyers, normally to the tune of 10% of the value of the property. But depending on the circumstances, that can often be negotiated if they haven't got access to 10% of the funds at that particular moment. But what it does, it means that both parties are locked in and nobody can walk away without it hitting them hard in their pocket. And if you're the buyer and you decide to walk away, you lose your deposit as part of the penalty.
Got you. I mean, I've seen transactions fall apart over the most ridiculous things, like the vendor wanted the purchaser to purchase the oil in an oil tank.
I've seen that, yeah.
Whereby the new owner's going to be, or the buyer's going to be putting in a new electric system or a different type of heating system. They don't necessarily want to buy the oil, but we always advise our vendors to siphon the oil out.
Yeah. Well, it can amount to several hundreds of pounds, but it is quite laughable when they might be selling a house worth £600,000-700,000 in a nice housing estate, which is mad prices, I know, but that's Jersey. And for the sake of a few £100, get a bit shirty about things like that. But often you find it's human nature. I mean, everybody's different, and sometimes people they've got cold feet and they're looking for excuses. And again, if you're acting for a client that you can tell is dithering or hoping that it'll fall away, then you just have to try and flush it out of them. Say, look, are you sure you want to go ahead with this? And then quite often people that are selling have got their heart set on a replacement property, and again, human nature. They might have got let down, or somebody might have come in and made a higher offer, and so there's like, not quite ready to move yet until we find something that we were hoping to get. And so they quite often, again through human nature and circumstances, will say to their buyer, I'm sorry, but we missed out on the one we're buying. We're either pulling out or you'll have to wait until we find something suitable. And this is why every single transaction is on a case by case.
Every transaction is unique, isn't it?
It is, yeah. I mean, I often have discussions with our accounts departments and the finance managers in various law firms over the decades I've worked. And I might be doing 2 properties in the same housing estate or close. And I might incur £5,000 worth of work on one and £2,000 worth of work on the other. And the finance guy who won't have a clue about how conveyancing or the system works, will say, why did that one have so much more work on it than that one? And I'll say, the clients were different, the circumstances of the properties were different, there may have been a planning application that hadn't been signed off on one but it was on the other, a boundary might have changed on one but hadn't been changed on the other, and that could be 2 mirror properties but with 2 different families, 2 different sets of circumstances, and so that's why it's impossible to predict exactly what is going to unfold. You just try and use your experience to get to the nitty-gritty as quickly as possible.
Yeah, so it's all very serious business, particularly when you're dealing with someone's perhaps largest asset, whether they're buying or selling. But surely you've got a couple of funny stories you could share with us about some things you've seen along
just
the way.
to finish on your serious note, this is what sometimes frustrates me. It is a stressful thing, and we are playing with people's lives. And so that's why everybody needs to try and communicate as efficiently, including the clients themselves, as possible. Because otherwise it just adds to what is already a stressful experience. All right, funny stories. Some of them I can tell, or a couple I can tell, but some I probably can't tell. I remember when I was still training, I think I was about 5 years in, and so I was with a senior colleague. In fact, there was two senior colleagues, and I was there as their hoppo to hold the end of the tape. And we arrived at this luxury house, and a rather wealthy lady came out and said, I'm just going off into town. Whatever you do, don't let my cats out. And they had a huge cattery outside in the garden of the premises. It was a great big manor house. So off she goes out through the gates, and almost by magic, one of the cats just knocked the door open of the cattery, and these £500, £1,000 Persian cats all start escaping and running around this property. And we started from here, kitty, 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 trying to get them back, to literally running around this large garden. I can remember me chasing them as a younger man. I could run them, and my colleagues literally trying to catch them like goalkeepers. And I think we managed to get one back in out of about half a dozen. Bearing in mind they were worth thousands, these things. And then we quickly did our boundary checks and conveyancing work and scarpered as quickly as we could before the owner came home.
Oh goodness, try explaining that one.
Yeah.
No, I was doing an open viewing in St Peter a few years ago, and I was warned about the chickens, and I was popped out to the garden, a busy open viewing, and came back to about 40 chickens clucking their heads off all over the property. Yeah, I've never had to handle a chicken before.
Yeah.
Live one, sorry. And yeah, I was straight on the phone to my dad, who looked after poultry as did his father, and yeah, it's embarrassing to say, but I had to give my dad a call to come and get rid of the chickens, but somehow they all left on their own accord. But
Well,
yeah, that wasn't a whole lot of fun. But yeah.
most of the funny stories do involve animals of sorts. I've been chased by a few dogs. I remember a colleague of mine got bit on his hand by somebody's dog. The owner said, just call his name Mulligan, and he'll come wagging. He's friendly as anything. So we open up the property. We had to go through the house to get to the back garden. So my colleague was saying, Mulligan, 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 and this dog comes up and he puts his hand out to pat him, and Mulligan goes, blood, drew blood, and my colleague just ran for it and left me with a flipping dog. So I had to go and calm him down and take him out and go and do the back boundaries on my own.
It doesn't come out without its dangers, the
No.
jobs. I've been knocked out once in 25 years by a loft ladder, but
Oh right.
other than that, I've been largely unscathed.
Well, the one final story I'll finish with you is that I was out on site with a lovely chap I used to work with, and he's very mild and meek-mannered, very church-going and stuff. And we went to this property. It was up near the war tunnel somewhere, and we were told we could get round the property. We didn't need to knock, and we didn't need to go inside. That there was a side sort of pathway with a gate into the back garden to check the rear boundaries. So I'm round the front taking photographs and checking the boundaries at the front. So my colleague says, "Oh, I'll just go round the back and see if the gate's open." So he went down, he opened the gate, and unbeknown to him, this lady was lying on her sunbed, stark naked. And he came tearing down the pathway, and all I could hear was her screaming, running into the house, trying to put a towel around her, and him running back towards me. "There's a naked lady, there's a naked lady." That was a funny one.
I remember my dad had to sack our gardener once. I came back from school poorly once, and I remember bringing my dad and said, "Dad, there's a naked gardener in our kitchen." Yeah, he lost his position that afternoon. But
Oh dear.
yeah, you see all sorts. But yeah, we're pretty yeah, limited what we can share. But yeah, we've had a few stories shared between us over the years, and
Yeah.
we used to work in the same law firm a couple of decades ago. Hey, Shaun?
Yes, yeah.
But no, it's great to have kept in contact, and thanks ever so much for your time today.
You're welcome.
Really appreciate it. I know it's Friday. We've got court in a couple of hours. You've got any going through today?
Well, I'm not actually in the office today, so I'm only working flexible part-time at the moment. I've done my 42 years down the pit, so I managed to downsize, buy a little place in France, buy a bit of land, and be a bit of an amateur gardener or farmer. I love my spuds and onions. And I bought myself the boat of my dreams. So I only work 2 days a week now, working flexibly part-time. But I'm always at the end of a telephone.
Yeah.
Not so much email now, because email dominated my life for long enough.
No, you make our life very easy. You're always contactable, whether you're working or not. But I guess that's the nature of our relationship.
Yeah.
And no, you're incredibly good at what you do, and you instill great confidence in both our buyers and our sellers, and we do get good feedback on you. So keep up the good work, and don't leave the industry too soon, Shaun.
Okay, I'll try it.
Thanks ever so much.
I've enjoyed driving around in the little toy car.
Good. Right, that's a wrap. That's a wrap. We can swear now.